I won't delay you too long, Cathaoirleach. You know, there was a question earlier there in relation to the opinions of various contributors, but obviously, at the end of the day, our job here is to listen to the opinions of people who come in here. We'll have to make a judgment individually and also as a member of as a committee, ultimately in relation to those judgments. So I value any opinions that we get here from either side. But it's quite clear, I think, from listening to the contributions from the Commission representatives today, that any reasonable and common sense reading of the situation is that the Commission's situation and position has been inconsistent, has changed between 2010 and 2016, and in my view is now an openly and nakedly political position. Just to say that as an introduction, I have two questions, and in relation, and maybe the two legal people and Mr. Dardir might answer this. In relation to the German case with the European Court of Justice, I'm reading here that it said it held that the failure to put in place a pricing policy on a specific matter without any complaint that this resulted in a failure to meet the objectives of Section 9(1) or the directive as a whole was not sufficient to establish a breach of Germany's obligations. Am I right in reading that to say that the lack of a pricing policy did not make Germany in breach of the obligations? I think that's and I'll just ask the next question for time considerations. The other question is in relation to full recovery of costs. And again to the same three gentlemen, am I right that the question of full recovery of costs was in the original draft directive, but it is not in the actual directive? So,
no. In relation to the first question, the short answer is yes. In relation to the second, yes. In other words, in the German case, the absence of full price recovery didn't render Germany in breach. In relation to the second point that you make, namely whether it was full cost recovery was in the original proposed directive, yes, it was, and it was withdrawn following conciliation at the Parliament, and that's recognised in the document I was looking at from the European Parliament. I'll read it into the record so that you've got a record of it. It's A50214/2000, and what it reads, the relevant bit, I won't read it all, is water pricing is a sensitive issue for member states that have particular regimes for exempting certain categories of users. However, in the conciliation, the attention focused on Ireland. It is the only member state that does not charge households according to water and sewage volume, but finances these services via taxation. At the end of the conciliation, it was agreed to provide for the member states to be able to opt out from the obligation of cost recovery if this is based on established national practices. That is why when I spoke earlier, I spoke about it being the Irish exemption. It was a clear recognition at the time by all involved that Ireland had an established practice. There was an acceptance that Ireland could continue to have that established practice, hence why full cost recovery was dropped out of the directive as we now have it.
Do you want to come in, and then Mr. Romero?
Yeah, I'd be very brief. I would agree with my friend, and I would just add that I suppose if you were to think of the German case, for me it emphasises the margin of appreciation in terms of cost recovery and the implementation of that. Margin of appreciation is effectively the discretion given to the member state. And I mean, the German case has been quite criticised by leading academics because of its decision, but it reinforces, if you like, the outcome of the decision in the sense that it does really emphasise that, and I think the Commission representatives have supported this today, that it does emphasise the margin of appreciation that's left to the Member State. And again, I would just finally add that you have to look at it holistically. It's Articles 4, 9, 11, Article 5. It has to be looked at in the round, and I think that's what the Court did.
Thank you. Mr. Romero, do you want to come in briefly?
Thank you very much. Indeed, the German case, basically, in a nutshell, the Court says the absence of a water pricing policy for a given water use is not in itself a breach, because there is an exemption, which is 9.4, which allows Member States, under certain conditions, not to apply water pricing policies to certain water use activity. This is the reasoning. And of course, this doesn't apply to, in the case of Germany, to domestic water pricing, because Germany has a system of domestic water pricing which is generalized, which is based on metering and usually a tariff which has a fixed and a variable part, etc., and has a full cost recovery obligation in their law. I'm talking about full cost recovery. Well, we can do, of course, legal archaeology, and sometimes it helps to understand and to interpret what the intentions of the legislator was. But indeed, there is no hard obligation for 100% of cost recovery in the Water Framework Directive, because there is a principle of cost recovery. There is an obligation to establish cost recovery, but there is some flexibilities in the last paragraph of Article 9.1, where it says that Member States, in doing so, may take into account social, economic considerations and climatic conditions. So it is for Ireland to find its way, a solid way to have a consistent system that is that justifies, that can achieve the goals of the Water Framework Directive and can consistently deliver good funding for the water infrastructure that is in need. Thank you.
Thank you. Ms. Graham, do you want to come in briefly?
Simply on a point, I suppose, of information, maybe just at this point, obviously members are exploring, I suppose, maybe in synopsis there seems to be three kind of the existing regime, which includes a suspension, no charges funded entirely from taxation, and a scenario based on the expert commission report. And I suppose from the evolving conversation, there are obviously very different perspectives associated with that and risks associated with what would be a compliant funding model. I didn't want to get precisely into that, but simply for the information to say the focus has been on what we have said in the first River Basin Management Plan, was simply to inform members that we are now in the process of doing the second River Basin Management Plan. We are close to going out to public consultation on that. It will simply reflect the fact that the Oireachtas, I suppose, is seized with looking at this issue at this stage, and then we'll be finalising those plans. And in those final plans, we, as a state, will have to set out how we are, whatever model has been chosen following the process, is in compliance, and that will have to take account, obviously, members are informing themselves in order to weigh up the risks associated with different models. So it was just simply to say that that timeline is during the course of this year. By the end of 2017, we will be finalising the second cycle River Basin Management Plans.
Thank you for that.